Welcome back. Now, let's discuss some more politics, and this time with the Labour Party. In a unanimous judgment delivered on Friday, the Supreme Court has set aside the judgment of the Court of Appeal in Abuja, which recognized Julius Abure as the national chairperson of the Labour Party. A 5-member panel held that the Court of Appeal lacked jurisdiction to have affirmed Abure as chairman of the Labour Party, since the substance of the case was about the party's leadership. It also held that the issue of leadership was an internal affair of a party over which courts lacked jurisdiction. The court allowed the appeal filed by Nenadi Usman, a former senator representing Kaduna South, and held that they were meritorious. It then proceeded to dismiss the cross-appeal filed by the Abure faction of the Labour Party for lacking in merit. However, the Supreme Court's ruling deepens the Labour Party's internal leadership crisis as questions remain over who holds legitimate authority within the party. Both factions in the party are claiming victory of the judgment. While one side says the judgment means Abure still remains chairman of the party, the caretaker committee of the party says the judgment means Abure has been sacked. Joining me now to understand all of this is a legal practitioner, Malaki Ogumadu, who joins us from another part of Lagos. Malaki, thank you very much. Help us to understand this judgment by the Supreme Court, because to be candid, even myself, I'm actually confused. I really don't understand it. What exactly does it mean? We have the Supreme Court saying, look, the Court of Appeal lacked jurisdiction to have entertained the matter in the first place. The Court of Appeal also held a similar view over the judgment now that came from the Federal High Court. So what then is the exact situation, or what should be the exact situation of things in the Labour Party? What does this judgment mean?
Well, let's be modest enough and accept that there's so much ambivalence out there regarding what has happened. This is precisely why, in most cases, we refrain from making commentaries when we have not read the enrolled order or the full judgments of court. I must confess that I haven't seen the judgment. I've been in the court all the day. But as it stands now, what I could gather from, snippets of the reportage that has gone into this is to the effect that the Supreme Court has had the opportunity to entertain this matter as the Apex Court and Final Court, and came to the conclusion that the lower courts, albeit the Federal High Court, presided over by Justice Emeka Nwite, and the Court of Appeal of Abuja Division, ought not to entertain the matter, having regards to the fact that the matter revolves squarely around the issue of leadership of the political party, and came to the conclusion that plethora of judicial authorities exist in support of the view that leadership of political parties are internal affairs of the political party.
But isn't that confusing?
Ought to decline jurisdiction.
Sorry, Malaki, but isn't this confusing? If the court lacks jurisdiction over the leadership of a political party, and then you have a contestation or a contention, the leadership in question is in contention. You have two sides now, pulling at themselves over who is actually the legitimate leadership of the party. How do you then resolve that? I mean, take a look at the Labour Party crisis, for instance. You have clearly two leadership, parallel leadership, one not recognizing the other not giving way at all for the other as well. How then do you resolve this issue? Okay, now the Supreme Court has said, look, the courts lack jurisdiction to intervene, to even do anything about it. So how then does the issue get resolved? How does it get resolved? How do we know who the authentic leadership of the party is?
DEJI, you are very experienced in this whole thing that all your questions are to be taken not just seriously, but with deep introspection. Here is the point. You see, the whole idea of political activity around political parties is to ascertain the desire of the people, not the wish of the court, not the discretion of the court, not the expectation of the judiciary in erecting leadership. So the question you have asked asks us as not just lawyers, but political scientists to now consider the bigger question as to what would be, where would contestants, where would adversaries go to, where the issue of leadership of a political party arise. And if we claim to be citizens of a country in the Committee of Civilized Nations, it is expected that where disputation arises, whether in political parties or outside political parties, they have the judiciary to resort to. That is the expected position. But the Nigerian court and in the development of the jurisprudence of our legal system have found that what politicians do most often than not, and to the discredit of party politics, is to leave that arena that involves the participation of the people to choose leadership and ascertain the will of the people, and then resort to court. So what the courts have done over time in trying to mitigate this penchant for excessive litigation is to now make pronouncements over time and with respect to other life cases that where the issue has to do with the emergence of leadership of a political party, it can only be resolved within that political party and not outside the political party. And therefore, issues squarely around proper leadership of a political party cannot come to court. In other words, an exemption has been made with respect to the emergence of leadership of a political party. As to the general concept of ubi jus, ubi remedium. In other words, once there is a wrong, there must be a remedy right in court. In this instance, it behoves the political parties who are expected to be able to organize themselves within the confines of the rules that they have agreed to bind them, and through the participation of members of the political party to enthrone leadership. In fact, I think that the idea is to continually remain focused on creating leadership through the people. It can be extended to believe and argue that in the same vein, efforts are being made to ensure that what becomes of the outcome of elections generally beyond political party should be resolved in the polling booth and not through the court. So, Mr. DG, you are, as I know, just let me land on this if you don't mind.
Yes, go on.
The position as it is that whereas it is desirable and whereas it is consistent with all activities within a civilized societies, that disputations, disagreements are to be resolved either through ADR, getting to the emergence of the leadership of a political party. The courts, albeit the Supreme Court of Nigeria, had repeatedly insisted to resolve within the political parties and not burden the courts with the issue of elections and leadership of political parties.
So now what I'm wondering is, how then do we know which of the leadership is... okay, for instance now, does it mean as it stands now, it is any leadership that INEC recognizes that then becomes the authentic leadership of the party? Is that what, I mean, this would eventually amount to? Because INEC would just have to recognize one over the other.
Obviously, there is a challenge, and it is no use running away from it. Because in my view, it is almost an escape attempt, which will leave even the party with greater challenge. Now, the principle of law has been established, but to what extent does it deepen party politics as the only vehicle by which democracy can be delivered? In my view, it's already a problematic situation. Now, what the court has said from the snippets of the judgment that I have read is to the effect that the lower courts, i.e. the Federal High Court and Court of Appeal, ought to decline jurisdiction once they realize that the issue has to do with the leadership of the political party.
Yes.
If that is the position of the Supreme Court, which is the highest court, and mind you, Honorable Justice Chukwudifo, put our blessed memory, has always warned that we are infallible because we are final. It is just the fact of our finality that makes us infallible. What it presupposes is that they can be wrong as well. So where that leaves us is that it is now a combination of the effort of the political party, which is expected to be able to enthrone leadership seamlessly, for that matter, and the election monitoring bodies, which is saddled with the responsibility of not just observing but coordinating the activities of the political parties, that will be able to establish what the leadership of that political party is. So, but in very clear terms, that is already going to create sufficient crisis, because both contending parties are digging in and laying claim to the leadership of the party, and I don't personally see how they can wriggle out of this. Worst of the situation is that the Supreme Court has spoken, and you cannot now bring another matter up because with respect to the leadership of the political party, the Supreme Court has spoken. So I'm in sync with you to say that this is a big challenge. This is a big crisis. It has left the parties much more vulnerable than they were before they approached the court. And it's only going to be what INEC now says, as to who is the appropriate leadership of the Labour Party. But by and large, what I see is a very weakened Labour Party arising from this crisis that they've been unable to manage.
No doubt at all. Malaki Ugumadu, legal practitioner, thank you very much for talking to us, and thanks a lot for your time.
My pleasure.
Thank you.
Thank you.
All right, that's how much we can take on the program. Well, thank you very much for watching. I'll see you again next week. Bye-bye.